Hello, my name's Dan Dodds. I'm the principal attorney at the Dodds Law Firm in Surprise, Arizona. Today I wanted to share with you and explain what an alternative beneficiary is. So I think I can give it in an example and explain it much more clearly than I can define it in legalese terms. An alternative beneficiary is someone who isn't necessarily going to inherit something out of your estate. You've already named it to somebody else. But should that beneficiary die before you do, it would have lapsed. In other words, the person you left it to no longer is on this earth. So it would lapse and it would not be awarded to that person or anybody else. So how do you get around that so you don't have to amend your trust? You do it by naming an alternative beneficiary. So let me use an example. Let's say that I own a cabin at Pine Top, which I would love dearly, but I don't. But it's a beautiful place to visit. So I have this cabin at Pine Top. I love it because my wife and I, we go up there, we do a little fishing, we have it there if we want to go skiing in the winter, and we just love Pine Top and its many restaurants. So I decide that I'm going to leave that cabin to my eldest son. And I have other children, but I'm going to leave it to my eldest son because they're very outdoorsy. They like to ski. So that seems reasonable, and I'm going to leave my other stuff to the other children. But for some unknown reason, he prematurely dies before I die, then what happens to that gift? Well, as a legal matter, it's lapsed. In other words, it's failed because he's no longer can inherit it because he's not alive. So what do I do to solve that problem? Well, you can avoid having that gift fail by doing one of maybe three things. One is, in the focus of this beneficiary, is to name an alternative beneficiary to take the cabin if my eldest son died, so it would not fail. So I could say, okay, I'm going to leave it to my eldest son, but if he should die, I'm going to leave it to my daughter. Or I'm going to leave it to my son who's passed, leave it to his family. So that I wouldn't have to go back and amend the trust and the gift would not fail. That's one way of doing it. Another one would be, I could say, well, I don't think that's going to happen, but if it does, I will go back and amend my trust and decide then who to leave it to. That's an option, other than it puts the burden of me having to go and amend the trust, but that's one way of doing it. Another way is, I'm still alive. I don't want to amend my trust. So what I decide I'm going to do is I'm just going to sell the cabin, take the proceeds, and I've probably got a provision in my trust that says, well, how do you divide the cash that might exist in the trust? Well, you're probably going to equitably divide it between your children. Or you're going to leave 10% to your church and then have the rest divided between your children. So there are ways of dealing with it, but you want to avoid this scenario. My son dies. I did not name an alternative beneficiary. The shock of me learning of his death causes me to have a heart attack, and I die. Now who decides what happens to the cabin? If I don't have a provision in my trust, well, you'd have to go to the court. And it's best to avoid that and the cost of it. So naming an alternative beneficiary makes some sense in some circumstances. If that was your only son and you're leaving your estate to other people, well, then maybe you want to amend your trust because maybe that cabin's worth a lot of money and you don't want to see it divided up equitably. Well, I hope this information helps educate you as what is an alternative beneficiary and why you might want to consider naming an alternative beneficiary, particularly if it's a sentimental gift that you've left to someone or something that has significant economic value. Hope that information's helpful.